Good morning. It's 10:30 on Thursday. And for those of you that have been with us throughout the month of April, welcome back. For those of you joining for the first time, we're really glad that you have chosen to spend your time with us this morning. For the next 90 minutes, we'll embark on our recent webinar here called The Responsibility and Liabilities of Climate Speech. We'll be moving forward as another one of our series for the Center for Carbon Management and Energy. For those of you that don't know me, my name's Chuck McConnell. I'm responsible for the Center for Carbon Management and Energy here at the University of Houston. We've been in existence for not quite a year and a half now, and really formed under the premise of working very closely with our people within the university in all different disciplines, whether it's science, engineering, business, policy, and of course, legal, and putting all of that together in terms of looking at the holistic approach to solving the challenges of carbon management in the marketplace. Those demands in the marketplace really are the other part, or where they come from is the other part of our center, and that is our industry sponsors and participants in our Center for Carbon Management and Energy. The energy industry, whether it's oil and gas, petrochemicals, or electric power, all are facing challenges with carbon management going forward. Many people making declarations about getting to net zero by 2050 and all of the necessary enabling capabilities that it will take to achieve those kinds of aspirations. Our center is grounded on fundamental principles. 3. First is that you need to have energy capabilities to meet the demand growth and reliability needs of the marketplace. The second thing is you have to have environmentally responsible energy. And whether that's your carbon footprint or any other part of the environmental footprint that any company has, it's an important and essential part of what is often referred to as the dual challenge: more energy and less carbon. But we actually put a third leg on that stool here at the center, here in Houston. And that is that it be affordable, cost competitive, and affordable for citizens, industries, and cost competitive on a global basis. And that's what our center is all about. And we embrace the challenges from the marketplace and the inputs from our industrial and marketplace participants, and also use that to channel the multidisciplined efforts within the university, working in collaboration, so that we can hit those marks and make the challenge. So today, again, it's another one in our series. We'll wrap up by 12 o'clock today. And we've done this every Thursday throughout the month of April, and we'll once again thank Hunton, Andrews, and Kurth, one of our principal founding sponsors for our Center for Carbon Management and Energy. They themselves have had a lot of effort within their own organization looking at new challenges in carbon management. One of our first webinars was about 45Q, related to carbon capture, utilization, and storage and IRS guidance. And Hunton has a broad expertise in the energy, broad-based energy transitional activities, whether they are renewables or traditional oil and gas, whatever the case may be. We're delighted to have had their sponsorship throughout this month, and what we're really delighted about is we'll continue to have their support and involvement in our center going forward. And by the way, next week, we'll, on the Thursday, again at 10:30, we'll have another in our series of these webinars, really looking at digitization in the energy industry. Actually, this afternoon, on our webpage, we will be posting a recently authored white paper by Greg Bean, who is our executive director of our Gutierrez Energy Management Institute at our Bauer School of Business here. That white paper will be the foundation for next week's webinar and really looks at the way the energy industry is being reconfigured, how the way we do work will be changing, how important it is for those aspects of all digitization, how it impacts the workforce of the future and the way we do our work. You can visit our website, the lower link there, to learn more about the webinars going forward. And I would also encourage you that if you've missed any previously this past month, the previous webinars are archived on our webpage, giving you an opportunity to maybe go back and review some of that material, or if you haven't seen it, take a look at it for the first time. We're continuing to aspire to have a library of resources and capabilities, and hopefully you can use that webpage also as a key way into our center, and for us to be able to provide any impact or feedback to you individually at your company or enterprise that you're working with. We're constantly looking for new activity in that area. During the presentation today, and actually after the presentation's over, during the Q&A session, you have a feature on your Zoom, which is the chat feature. You can enter your questions by clicking on that box. Those questions will come in and we'll archive those as we go through the presentation today. And we'll use those to spice up the conversation at the end of the presentation that you'll see at the very beginning. I want to remind everyone also to go into the upper right-hand corner of your Zoom, and if you're not using the speaker click, I guess, that is up in the upper right-hand corner, that will allow you to see the speakers and the presentation simultaneously, and hopefully help you see it more clearly. The gallery view is a little bit crowded, so I would encourage you to use that speaker view. So on to today. We have two of the most distinguished faculty that we have at the University of Houston, Victor Flatt and Tracy Hester. I can say that I'm privileged to be their colleagues and have associated with them since coming to the University of Houston. Our School of Law, especially, is focused in the energy area. As a matter of fact, I guess one of the founding principles of our law school here is, if you're really going to do the work in law in the energy area, you really need to know about energy, but you also need to know about the environment, and you also need to understand the climate. And so that triumvirate, if you will, of capabilities and competencies is fundamental to being excellent in the practice. And that's a founding principle that we have had for really the inception of what we call ENER, which is our Environment, Energy, and Natural Resources Center. Victor's the faculty director for that. And of course, Tracy Hester is one of our co-faculty directors for the Center for Carbon Management and Energy. So Tracy and I get an opportunity to work regularly and routinely together in that area. What we're going to talk about today is climate speech. What does that mean? It's really about what the enterprises that are in the world today are saying about the climate, and what kind of responsibilities and liabilities come from that conversation. It's a challenge, as many of these companies have made declarations to be net zero by 2050. How do you get there? What do you know? And what are you saying to the external world in terms of your investors, your shareholders, your employees, whoever that might be? So with no further ado, let's listen to Victor and Tracy give us a grounding here on the responsibilities and liabilities in this arena. And then, as I suggested, use that chat function, ask the questions. but I think you'll find the Q&A at the end of this presentation quite lively, and hopefully your questions will help spice it up. So thanks again. And with that, let's turn it over to Victor and Tracy.
Thank you very much, Chuck. It's a great pleasure to be here, and I'm very much looking forward to our discussion here today. Just to elaborate a little bit in your introductions for both of us. Today you have me, Tracy Hester, a professor at the University Eastern Law Center, and Victor Flatt, who is the Dwight Olds Chair in Law and co-director of our Environment, Energy, and Natural Resources Center. And we're going to talk a little bit about an emerging dimension of climate change law, namely the potential liability for climate speech. So just to set the stage a little bit, I'm going to talk a little bit about some of the fundamentals of the way the First Amendment protects speech and where it doesn't. Then Professor Flatt will discuss some of the potential liabilities arising from torts for liability for speech. I'll then talk about some of the same sorts of liabilities you might see in a financial disclosure context, particularly for asset valuation. And then Professor Flatt will discuss some of the issues we're seeing developing in terms of ethical dimensions related to climate speech, as well as representing parties who make climate speech. And with that, we'll have time for questions and answers for everybody. So with that, I'll begin by briefly talking about what the First Amendment does and does not cover. Now, as we all know, the U.S. Constitution does provide specifically in the First Amendment that the government shall not limit or prescribe speech. That oftentimes is misinterpreted to say that you are free to say whatever you want in any context, but it is obviously not the case. Legally, there is not absolute immunization for the consequences of false statements. And in particular, the long history of case law in the United States has provided that there are certain categories of speech which do expose the speaker to liability. Most importantly for our conversation today in the context of statements related to climate change effects are, one, false statements of fact. And this is a familiar category that Professor Flatt will discuss in great detail in a minute, namely things such as false statements that are defamatory or libelous or slanderous. The concept is that you can incur liability for intentional or otherwise negligent misstatements that do have harmful effects. Now, the First Amendment does provide some protections, and we'll discuss those in some degree, for certain types of speech in the public arena. And in particular, speech that deals with the criticism of government officials can be subjected to a higher degree of protection under the famous U.S. Supreme Court case, New York Times versus Sullivan. But the baseline is still true, that you can have liability, financial liability, for certain types of false speech. In the same sense, there's also liability for fraudulent speech, speech that is made in the course of trying to engage in a type of defrauding activity that is meant to lead someone in a misleading fashion to make a financial commitment. A three-card Monte card dealer on the street does not have a First Amendment right to talk customers out of their money. This type of fraudulent speech is regulated in particular in the financial arena, where we have seen liability imposed for false statements, intentionally false statements, that are designed to induce parties to make misleading investments, designed to mislead to the value of stocks or other types of assets being offered for sale. There is no First Amendment protection for that type of speech. And then last, the degree of protection under the First Amendment provided for certain types of speech can vary to the type of speech being made. And in particular, there's a category of speech called commercial speech, which does qualify for First Amendment protections, but not to the same degree of rigor as other types of speech made by individuals in the public arena in the exercise of democratic rights or in the open marketplace of ideas. So with that backdrop of the protection provided by the U.S. Constitution of the First Amendment and what it doesn't protect, I'll turn the baton over to Professor Flatt to discuss what sorts of tort liabilities might arise from this context.
Thank you, Tracy. As most of us probably learned from time as a child, lying just doesn't pay. And so if you think it's a bad idea, it probably is. But I want to be a little bit more specific about how and what legal theories underlie this. And I'm going to start with what we call tort liability. I'm going to share my screen now. Here we go with this PowerPoint, and I will start from the beginning. So, as Tracy says, we're doing climate speech responsibility and liability, and we're going to talk about first possible tort theories of liability. A tort is a wrong that one person commits to another. The common things we tend to think about are intentional torts like assault and battery, or negligence like speeding and hitting somebody with your car, or things like medical malpractice. But there are other kinds of torts that are of particular import to false statements of one kind or another. The first of these is called the tort of misrepresentation. That tort is completed by transmitting false information that someone relies on. And if that transmission of false information causes them to lose money or have damages, they can sue under the tort of misrepresentation. Sometimes, depending on the level of speech that we're talking about or the arena in which the misstatement is made, it needs to be shown that they knew that what they were saying was false. But as Tracy pointed out, there are differences in speech levels of protection between political speech and commercial speech. And so in certain cases, simply being negligent, not investigating the truth of the statements that are being made publicly, can lead to liability for misrepresentation. In the context of climate change, in the general tort category as opposed to specific financial issues, this could be accomplished or could occur if one company gives out statements that are negligently misrepresentative of the risks of the company's product, what that company provides, the risk of their financial valuation, which Tracy will get to more later, or anything else that could be relevant to a third party. So the first category then is misrepresentation. The second category is defamation. Defamation is libel or slander. Professor Hester referred to this. Defamation occurs against a person, and so in that sense, it can be different from misrepresentation, although the law does recognize that corporations can also be defamed. Generally with defamation, it has to be a provably false statement made against a third party. That's usually published, and publishing can mean electronic publishing. Certainly that's the most current way that we get information. I've put a situation up here. There's a famous case in which the scientist man at the University of Pennsylvania sued the Competitive Enterprise Institute magazine and some reporters for claiming that he was a fraudulent scientist and committed fraud for his work on the famous hockey stick graph with respect to climate change research. They attempted to block a lawsuit from him for defamation, but the court, the federal court that heard that case, said that there was certainly sufficient information to go to a jury, that a jury could find that there had been actual lies that were told knowing that they were false, and that the potential defendants could be held liable. This is an interesting case because it gets into the issue of when a statement is made, whether it's made for a political purpose or not, and I will come back to that momentarily. A third category in tort liability and climate change possibly is for products liability. Specifically, one of the categories of product liability is a failure to warn, and that is a failure to warn of damaging things that could occur from the product. Those can be damages to the user, damages to another person, or property damages. Every state has one of three tests on whether a failure to warn is met or not. There's the consumer expectation test. Would the consumer have expected to get a warning for this kind of product? There is the manufacturer's test. Should the manufacturer have provided that warning? And there's risk utility. Would it make a difference? Would it be a better situation for using the product if the product maker had provided the warning? We've already seen this claim utilized in some potential tort cases against large fossil fuel companies. In particular, the idea being that their product, in this case oil, gasoline, refined products, was more dangerous to the environment than they let people know when the product was sold, and that would have affected the sales and or the consumers might not have purchased that product. The last category of tort that I want to talk about is nuisance theory, in particular public nuisance. This is when a government official claims that a party has done something, they're doing something that is dangerous to the health or morals of the public at large. And this theory has been utilized across multiple jurisdictions to try to recover damages from major oil companies, claiming that their actions, in this case emissions, refining, selling, have created a risk, a health risk to the public. Now, that on its face doesn't sound like it has to do with speech at all. But it turns out that in some of the jurisdictions, including two major and important jurisdictions, there's jurisdictions of California and New York, that one of the things that the court takes into account in determining whether or not the action of the defendant amounts to a public nuisance is whether or not that defendant engaged in any bad actions. And by bad actions, they put in that category situations such as misrepresentation, false information, and fraud. Therefore, it's possible that speech, again, that is not true or is provably false, can cause a company to be more subject to liability for public nuisance in certain jurisdictions. There are a couple of key points I want to make before I end with torts of common themes. One is the concept of demonstrably false. Demonstrably false is a very particular standard. It means that something can be proven to be false. It is distinct from an opinion. So I could have an opinion that says, I believe Professor Hester's jacket is very handsome, but that's merely an opinion. And if I said something defamatory, like, I think Professor Hester's jacket is really not a good jacket, that can't be defamatory either, because it's just an opinion, and it's obvious that I'm expressing an opinion. On the other hand, if I were to make a very specific statement about something that we can prove to be true or false, then that can subject the party to liability under these various torts. So, for instance, it's probably protected speech when a company argues that they do not want regulation based on greenhouse gas emissions or climate. That would be protected because that's expressing an opinion or a belief, and a political belief at that. On the other hand, if that same party were to simply say, there are no scientists who believe that humans have caused the earth to warm, that is a demonstrably false statement. It can be proven to be false by reference to accepted truths. And so those are different kinds of statements. So it's important to consider what is demonstrably false from mere opinions. Mere negligence is sufficient in some cases to establish these torts. In other cases, you need actual knowledge of the falsity. And that really goes back to the distinction that Professor Hester talked about at the beginning, and that is the distinction between political speech or core First Amendment protected speech, and speech that is merely commercial in nature or only for the benefit of a private party. In those cases, you only need to reach a level of negligence to have liability. In core protected political speech, you must show that the party had actual knowledge that what they were saying or doing was false. And again, of course, we've had allegations in the various climate cases that some of the public statements that were put forward by companies were known to be false or untrue. Last, actual knowledge almost always equals more liability. So a negligent statement may lead to liability, but a statement made with actual knowledge of the falsity tends to lead to more liability. And it can open the way for punitive damages under torts, which negligent liability for false statements cannot lead to punitive damages, whereas actual knowledge of false statements can lead to punitive damages. And so these are just some of the factors that affect how the tort cases might turn out or how they might turn in a particular case. Tracy, back to you.
All right, then with that, sorry, switching screens around does take a little bit of time. So we've talked about some of the parameters of constitutional protection of speech and where they don't protect. We've talked a bit about how you can have tortious liability for reckless or intentionally misleading speech. I want to talk about a different category of emerging liability for climate statements. And this one deals with statements made in the context of financial transactions, and in particular, statements made in regards to the sale or transfer of stocks and securities. Now, in this context, you can say with perfect confidence or that you're not exposed to liability, a statement about whether or not you believe climate change is true. But you cannot make a similar statement that your assets that you are marshaling on behalf of your shareholders or for other parties you have a fiduciary duty to will not be affected by climate change. That latter statement is a matter of speech related to a valuation or statement for people who are purchasing securities or assets from you. In that context, the Securities and Exchange Commission has already issued guidance that gives some insight as to how they interpret the Securities Exchange Act to make sure that statements made to shareholders are true and do not fail to disclose any material liabilities. Now, in that context, the SEC's guidance from 2010 specifically states that climate change can raise material issues that a company must disclose to its shareholders. The types.
Can I interrupt you for just 1 second?
Of course.
Do you have this on a PowerPoint as well that you can share with the audience?
I think it was on my screen for the audience. Let me see if I can try and reset it so it is on the screen. 1 second.
Okay. Thank you.
Now?
Yes, thank you.
For those watching, yes, we are still working through the Zoomverse these days. So this PowerPoint slide is hopefully giving a little bit of a visual accompaniment to what I was just saying, namely that the SEC guidance for 2010 does give some meat on the bones for what the SEC considers to be principles guiding disclosures by corporations that sell securities to the public. And most importantly, one, that guidance does specifically state that climate change might rise to an issue that be material to investors wishing to purchase stocks in the company. The ways that climate change might pose a material risk that needs disclosure, according to the SEC, might include things such as legislative changes or indirect risks created by limitations in the way that they can operate or use assets. In that context, financial disclosure is a form of speech that could create liability if, for example, a company had assets that were going to be materially less than the value that they're representing to the public because of climate change issues or constraints on the emissions of carbon. And I'll discuss a little bit some of the particular dimensions of how that type of asset valuation and reservoir valuation may be a material issue for companies going forward. Now keep in mind, this is a federal liability issue under the federal securities laws. There's also a parallel layer of state liabilities and state statutes that set legal standards for the accuracy and truth of statements made by publicly traded corporations to shareholders. In particular, one of the most notable has been in New York State under the Martin Act, which provides under New York law a separate standard of accountability and accuracy for statements made for companies who sell or exchange shares within that state. And of course, given New York's location for Wall Street, that gives this particular statute a much larger presence than other states. Now, the Martin Act has a lower standard for proof of accuracy and intent for imposing liability. And the New York Attorney General has been notably active in bringing Martin Act prosecutions related to corporate disclosures that deal with climate change risks. In particular, there was originally, over a decade ago, a set of actions brought by the New York Attorney General against coal companies for failing to disclose risks related to climate change that might affect their future business operations and their asset valuations, which resulted in settlements, in particular, for example, by Peabody Coal, which required them to be more forthcoming and more comprehensive in their discussions of climate risks in their security statements. We have now had a new wave of Martin Act prosecutions, one of which was a notable high-profile trial that was brought by the New York Attorney General against Exxon Corporation, which resulted in a verdict that was in favor of Exxon. However, that continuing possibility of state liability is still rolling forward. The Massachusetts Attorney General, for example, is continuing with their securities enforcement action. We've seen the prospect of other types of actions being raised by other attorneys general. For example, at one point, the Virgin Islands Attorney General was interested in bringing a similar type of action. That means that effectively companies, actors within companies are going to have to watch the accuracy of their statements about climate change posing a material risk to their operations and assets in the near term and long term. Now, the area that is most likely to have an impact is going to be in terms of valuation. Now, normally, how you value a company's reservoirs of, for example, hydrocarbons is a very complex task. And depends on the interconnection and balancing of factors related to the cost of removing those hydrocarbons from the ground, the likely market demand for those hydrocarbons in the future, the ability to sell them at a certain price. Now, that means that you have, for example, difference between absolute and recoverable reserves and what the long-term prospect of being able to develop those risks in those reservoirs in a timely fashion that could actually be an asset that could be sold in the market. Well, if you start factoring in the prospects of constraints on carbon emissions, those can be used to provide a lens as to the possibility that there will be increasingly substantial portions of underground reservoirs of oil and natural gas, and in particular coal, which may not be ultimately recoverable because of constraints in the ability to burn them because of carbon emissions. That would translate these potential reservoirs and assets into stranded assets, assets that cannot be economically exploited and ultimately are written off. That has context both for securities sales, but also has a context for straight up commercial transactions. If you are selling oil and gas assets to a buyer, you will typically have to warrant and represent the commercial viability and sufficiency of those assets. If those warranties and representations turn out to be inaccurate, you may be subjected to liability in a straight up contract action or other types of commercial liability vehicles for inaccuracies in your statements. If you obtain a loan that is going to be backing up that transaction and you make warranties and representations as part of that financing, you may face similar types of risks for inaccurately stating what types of liabilities may undermine the value of those assets. To give you a bit of a flavor of the complexity of how these work, this gives you a sense of how you have to combine a valuation of both the cost of producing the asset and the ability to actually use that asset. These are actual economic analyses that were done last year prior to the destruction of demand due to the COVID pandemic. And what I'd like for you just to notice is on the left-hand set of graphs that the vertical axis for 3 of the 4 graphs is the cost of production. And the cost of production is gauged to either BTUs or cost per barrel or cost per ton. And what you'll notice is that you're still looking substantially at, that some reserves are not going to be economically recoverable once you get above, the vast majority of them, if you get above $40 a barrel, they become recoverable, but less than that, it's questionable. It is interesting in that these analyses were done with the idea that we may be seeing a cycle demand destruction that is due to the fact that renewable energy sources are becoming increasingly cost competitive, and that as a result, it will become economically unviable to sell certain types of hydrocarbon or fossil assets, which would lead to an increasing oversupply of those assets. And then at that point, a demand destruction for economic reasons that would result in a downward spiral of the value of the asset. The COVID epidemic has presented an interesting test case where we're actually seeing some of these modeled assumptions playing out in real life. And as a result, a lot of valuations for reservoirs, a lot of valuations for assets being held in hydrocarbon portfolios may get a re-examination to determine whether or not prior valuations and prior representations made as to the economic worth of those assets are still true. And if that reevaluation process may bring to a particular sharp point some of the issues of liability for statements made as to the value of those assets.
Tracy,
with that, I'll turn back to Victor.
Oh, wait. Well, before you do,
okay.
This is also a good time to, I think, to once again note the distinction between politically protected speech and commercial speech. All of what Tracy has been discussing in terms of what information included in SEC, that Securities and Exchange Commission filings that are provided to investors, shareholders in terms of commercial contracts, that is all commercial speech. And what that means is the company doesn't have to have intentionally misstated the value of their assets. In fact, it can be a negligent or a misstatement of the assets. So what that means is it's required of a company to identify what is material and then to identify the correct information. And as Tracy has suggested, of course, that can be very difficult. And so what we tend to see then is that companies may go back and revise those over time, and that duty is an ongoing obligation for them to do so. Also spurring that, and I think, Tracy, you might have mentioned this, is if there are misrepresentations that are made to the market or potential buyers of stock, shareholders can also bring lawsuits claiming that they were induced into buying and or selling stock by false or negligently provided information. So this is a really, I think, a potentially even bigger place that companies may falter because it doesn't require them to have made any sort of intentionally false statements.
And Victor, that's absolutely true. And I'll add that Exxon has already had shareholder derivatives actions brought in Texas, specifically on the issue of valuation of assets in light of climate risks. And so it's already starting to happen.
Okay, thank you, Tracy. Now I'm going to go back to our PowerPoint here. Oh, that's Tracy's PowerPoint. I'm sorry. I'm going to stop that one and share my PowerPoint. Here we go. Okay, so again, let's go on to this. And here we go. So the other or last category or big category that we would like to discuss where there can be liability that is related to false speech can be liabilities with attorneys themselves. And this is a relatively new category that is being explored. And this is what we would call derivative liability, not to be confused with liability for derivatives, financial derivatives. But this is liability that would come for an attorney from doing something that was wrong in their representation. And that can occur particularly if an attorney is representing a client who may do something that would be considered in the wrong. And so just to start this, attorneys themselves cannot make or abet a knowing falsity. So an attorney cannot make a false statement that is a violation of ethics rules of every state. Now again, political opinions are different. But knowingly false statements can result in ethical violations for that attorney. And an attorney is also required under ethics to advise clients against knowing falsities, particularly as they relate to commercial fraud or could violate any disclosure laws. And so right away, if you imagine a corporation, a company, any large corporation, but a major energy corporation, in order to function, they need the services of attorneys. And attorneys then apply a check, in theory, on their ability to utilize false statements, particularly intentionally or known false statements. Another question that I've been looking at myself is whether or not the falsity or the issue could lead to death or substantial bodily harm. And with greenhouse gases, there is a potential question of whether not whether greenhouse gas emissions cause harm, but whether that kind of harm would qualify under these state ethical rules. The ethical rules vary between states. Often the need for disclosure is related to whether or not the action taken by the client might be criminal or fraudulent. Some states do not require that. And so in certain cases, if you're representing a party who has made a false statement that could result in more greenhouse gas emissions, you may be required to disclose that information to proper authorities. All of these things work towards a situation where attorneys may be fearful of continuing representation in situations where their own liability could be at risk. So while a company has their own rules governing what false statements they can make and how those false statements can be punished, attorneys or attorney law firms that represent these corporations also have to look at liability they can get from representing those companies in relation to these categories. And that becomes another potential landmine, if you will, for companies that are seeking, of course, to function as a normal ongoing business concern. Tracy, I don't know if you have anything you want to add to the ethics part of this. It's just a little bit of an overview.
No, I expect we'll have lots of opportunities to answer and talk about this during the Q&A session, but I did have a small postscript to offer up on liability issues that relate to our corner of the universe dealing with academics.
Okay.
So, I'll see if I can pull that screen up real quickly. Okay. I imagine many people listening in on this presentation are in the academic universe. So I just wanted to point out that we actually have to wrestle with this issue in a bit of a more direct and personal way. Namely, a lot of academics, particularly those of us who work in public universities or state institutions, are under an obligation for all of our academic records to be producible under Freedom of Information Act request or Open Records Act request under state law. That has led to a host of litigation by persons who challenge some of the statements made by academic client scientists regarding climate change rates, impacts, and effects. So as a result, academics are wrestling with to what extent are we facing personal liability for statements we make as academics in the context of talking about climate change and a highly politically charged atmosphere. As backdrop, is one question is to what extent we speak as agents of our institutions. And what you might be surprised to discover is that a lot of institutions do not provide automatic protection for professors who make statements as part of their academic work. So that doesn't mean that they can't, but it doesn't mean that it's guaranteed as part of either for tenured or non-tenured faculty. As a result, we're starting to see a strange new variety of litigation brewing over the use of what are called SLAPP statutes dealing with academics. SLAPP is an acronym for the concept of strategic lawsuits against public participation. The idea is that a lot of persons may make a statement that they are sued for in arguably in a frivolous lawsuit or a lawsuit that has a very low chance of success, but the cost and inconvenience and risk of answering that lawsuit in and of itself chills speech. So many states have passed statutes to make it easier to dismiss these kinds of lawsuits. Well, we're starting to see SLAPP statutes applied in the context of lawsuits against academics for climate claims, and vice versa, if an academic sues someone for defamation because he or she believes that they have falsely made a statement about what their research says, SLAPP statutes have been raised in that context against those lawsuits. We're still sorting out how that will all play out, but it is definitely beginning to skew the way academics talk to each other in this arena. It's definitely a new variety of liability for climate speech. I did want to mention one point that Victor raised that's well worth your attention, namely the Mann versus Competitive Enterprise Institute decision. That was a case that actually was appealed all the way to the Supreme Court just last year. And the Supreme Court, like it does with most cases, refused to hear it. But it triggered a very emotional, passionate dissent by Justice Alito, who believes that the right of freedom of speech plays a central role in weighing claims that are being brought related to veracity of public statements in an academic context. And so stay tuned. There's clearly some interest in the high court on the issues of how this liability may play out. And as a result as well of this brewing issue, we've actually seen the creation of a climate science legal defense fund, which is actually providing pro bono assistance from law firms and lawyers to help defend academics and climate scientists who are facing these kinds of claims. So stay tuned. This is going to be a very interesting and new field of law. With that, Victor, did you have anything else you'd like to add before we pass the baton?
Just to say thank you, Tracy. And I think what this points out for all of us, of course, is that this is as we've all known and learned, climate is a very controversial concern. It's risen in ways that may have made it perhaps more political than it would have been considered at one time. And that creates risks for lots of different people. But I do think the last point I would make and reemphasize, and what was emphasized in the Mann case as you were reviewing that, is and which Justice Alito I think was challenging, is at least at this time we do have a legal test. And again, opinions, political opinions are to be protected. Demonstrably false statements are not. And so at least for now, that tends to be the line we see in what could be considered for protection for speech or not. And I guess with that, we'll turn it back to Chuck.
Great. I'm looking forward to talking about this with you in the Q&A. Chuck, It's all yours.
Want to remind everybody to continue to submit questions using the chat function. We've had a number of really good questions already coming in, and let me get the video back on. There we go. So yeah, great presentation by both of you. Lot of interesting concepts. Before I get into the guts of all of the questions, I really start maybe philosophically with both of you. The word science gets used an awful lot by many people. And it's often the person that's speaking is the one that's owning the science at the moment the conversation's going on. So let me just paint an example and maybe you can reflect on it. I think people generally know that climate change is occurring. That is an absolute fact. Ice caps are melting. significant rise in water levels, et cetera. It's impacting things. And I suppose if you were sold a piece of property on a polar ice cap that was melting because of climate change, pretty straightforward. I guess the real challenge, and this is where I'd be interested in your perceptions here, is there's still a lot of debate about impacts and what's causing the climate change. Arguing about whether or not it's happening or not seems to not really be a conversation anymore. It's really about what's causing it. And so then the sharp edges come out around issues like coal-fired power plants, et cetera. I wonder whether or not you see a distinction around climate change and the acceptance of it generally, and then maybe more specifically, owning the science around what's actually causing it.
Thanks, Chuck. I'll start if you don't mind, Tracy.
Go for it.
So first of all, it's a very good question. And it's a very good question because we certainly know in different points in time, scientific information has been revised. What's accepted science at one point may or may not be at another, et cetera, et cetera. What we've seen with climate, which I think is interesting, is as it became politicized, you saw a movement from is it happening or not to yes, it's happening, which I think you have clearly, everybody seems to understand. And it's also a demonstrable fact that greenhouse gases such as carbon dioxide do act in the atmosphere in a particular way that reflects heat. That's just physics, right? It can be demonstrated in a laboratory. I feel like in the general public debate, it's also perhaps more settled even with both parties that humans are primarily responsible for that. But just to take your point, maybe that's not settled. But what I would bring you back to, and I think this is the interesting part of the question, is what can be shown to be demonstrably false or not, right? Mm-hmm. So again, you can prove it's demonstrable that if you put carbon dioxide just in an experiment and light and sun and stuff, it reacts in a certain way. That's just something you can prove and not prove. You can also prove, you can say it's true or not true that 50% of scientists think humans are a cause, or 97% of climate scientists think humans are a cause, right? You can prove or not prove that because it's you know, you can actually, there's a reference to that, right? You can see that. In the Mann case, the distinction there was that it was perfectly fine and not subject to liability for the magazine to say they disbelieved the hockey stick, or it was fine for them to say the hockey stick had flawed data, because some of the data was flawed, right? Absolutely, that is absolutely true, and it's not demonstrably false. What they said that was demonstrably false in that case was that Michael Mann himself had acted fraudulently, and there was had already been an investigation into that had said he had not acted fraudulently. So in that sense, once again, that was something that was demonstrably false. But you're right, if you want to talk about science, scientists almost never say something is 100%. I mean, everything's always a statistical probability. And that's always been one of the difficulties, I think, in translating science into law and policy. And the law respects that. So again, anything that's an opinion, even if it's a bad opinion, good opinion, any kind of opinion, if you want to say, I don't think humans cause climate change, you can say that. If you want to say, I believe the scientists that say humans do cause climate change, or I believe the scientists that say, or the 3% that say humans are not the cause of climate change, you can do that, right? And those scientists, they can say they believe or don't believe this based on their own studies and various other things. So it's only when it gets to something that is a fact versus not a fact. And I'll end and go over to Tracy with this example. You're talking about property. We saw an issue. So I would say, don't even talk about selling property on an ice cap. Talk about selling property in Miami Beach, Florida, right? As you have pointed out, you can measure the sea level rise there. Now, you may not be able to prove demonstrably yes or no how much it's going to rise in the future, right? We don't know. We can have estimates, we can have best guesses. That's not demonstrably one way or the other, but how much it has risen, how many storms occur or have occurred in the past is a demonstrable fact. And so that could, and it has actually gone to realtors now. Realtors have to be very careful about what they disclose in terms of selling property that may be subject to rising sea or flood inundation or that sort of thing. So I'll turn it over to Tracy. Sorry to talk so long.
No, it's a great answer because it's a big question, and I'll do. It's an enormous temptation for me, but I'll take a big question and move it over to a smaller universe, which just talk about specifically what's happening in the law world in that question. And it's worth noting that in litigation, in particular in some of the tort lawsuits taking place in California, the United States has been asked to essentially instruct at least one of the federal district courts as to what its position was on climate change. And it was an interesting opportunity to put a sharp point in that the government at that point conceded climate change is happening, conceded it was being caused by human activity, and conceded some of the impacts that climate change would likely have on individual municipalities and state entities. So as the form of law is causing us to put some of the questions about, the larger questions about science into that arena with liability associated with it, we're starting to see people putting their chips on what they actually are willing to defend and where they think there might still be some ambiguity. There's still a lot of fighting in terms of whether or not you can attribute some of those particular climate impacts to particular emissions by particular other entities. And that attribution link is still the focus of intense scientific work right now, and it is going to continue to develop. You'll see more of that sort of causation and proximate causation debate becoming the new science battleground. But notice that's for torts. That's for my emissions hurt you. It gets flipped in the financial disclosure arena, because if you are going to go with the conceded factual reality that climate change is occurring, and you can reasonably extrapolate what effect that is going to have, those graphs I put up in my presentation, I didn't dive into them very much, but they really boil down to a couple of things. According to one study that was published in 2015, they're saying that if you have a 2 degrees centigrade target, that's going to limit the ability to use only about maybe 30% of oil. You're looking about 50% of natural gas, and up to 80% of coal could be ultimately left in the ground, according to this one study, which was based on numbers that obviously the world's moved way past since then, but nonetheless, if you're making financial disclosures, you have to extrapolate those baseline assumptions to your particular company, and the numbers for high production companies and shale operations, climate change lands in a much more specific way, and those presumptions basically get flipped, the polarity is reversed, and you have to explain why it is you think those aren't true. And I think that's going to be an interesting question in terms of climate speech liability to wrestle with coming up.
Actually, I've got to add just one more thing to this, Chuck, because Tracy brought this up, and it gets back to the concept of carbon management, right? It's one thing you can assume how many assets are going to stay in the ground. On the other hand, if there's a particular cost-effective way to sequester carbon or pull carbon out of the atmosphere, so that changes that as well. Everything is dependent when you move forward, and that's why companies have to just do the best they can with the information that they have as it comes out.
Yeah, in those conversations, actually, it's sort of, in some ways it's muddy, but it's also clear, I guess, that there's a physical impact of climate change that could impact your ability to do your business. Again, going back to the facility that might be located on a coast that might have sea level rise impact its ability to actually function and provide products and services. I mean, there's a liability there that there could be risk associated with the physical ability of that location to continue to operate. Then there's the forward-looking view in terms of how climate change and the marketplace is going to impact the products and services that would come out of a facility. And there seems like a pretty strong distinction that the clarity around physical impacts versus financial impacts. And then there's always the safe harbor conversations around what your forward-looking views are on your products and services. Can you reflect on that just a little bit?
I think that's a very good distinction, Chuck, and again, one that's incredibly important. So if you look at climate risk, as you point out, there's physical risk, right, to assets of some kind, but there's also risks of product, right, risks to the market, risks of regulation, all of those things. And just as an example, if for some reason the cost curve were to change dramatically on one thing or another, right, if the federal government were to price carbon, for instance, would that incent more folks to look at how to sequester that carbon or manage that carbon? Or would it go the other way? Would it say, oh, we're just going to not do anything that's going to make carbon? I mean, so there's so many different things. And with a financial situation, when you're predicting, again, you have to do the very best you can. And there is some leeway with that. The problem is, since in that case, it's a sort of a negligence issue versus a false, non-false issue, right? Or false, true issue. The companies are always and should always be revising. And I would say you know more about this than I do, but I would say before we were involved in the climate crisis, you know, if you can go to some time back in the 70s or something, how companies valued assets and energy was always very difficult, based on, again, regulation changed a great deal, and there used to be more government direct regulation of energy than there is now in some cases. So yeah, and how do we price in whether Texas is going to or not going to restrict output from the Permian Basin? You know, again, but you always have to go back and do it. And I think where companies may run afoul is when it appears they may not have taken everything into account seriously. Right, that they pick one position or another because it makes them look better, or they prefer that, or they want to project this very positive image to their shareholders, which is fine as long as it's truthful and not a negligent, you know, problem with this.
And so safe harbor doesn't give you the ability to just say, look, forward-looking views, et cetera, You have to, I guess, the litmus test is, have you actually done your work in an honest way, right?
Right.
Yeah.
But it is worth noting that virtually every one of the longer range scenario planning exercises done by energy companies is very careful to state that these are not meant to be statements that should be relied upon for purchase of securities or assets, and that they're bracketing what they view as speech, which can be potentially a basis for commercial expectations that could create liability, and speech that doesn't.
Yeah, you know, you mentioned something, both of you actually, talking about valuations, et cetera, and we've wrestled as a country in whether or not we want to put a price on carbon. Should we do it? There is a global price on carbon, but it's not specific to the US. But there are some states that do it. It's a really troublesome challenge, isn't it, for industries or businesses to know what platform are they operating from? How do you rationalize that in terms of your legal best efforts to assess the risks?
I think it's interesting to talk about carbon pricing because, as you know, Chuck, most of the major fossil fuel companies have come out in favor of a carbon tax or another price on carbon in the United States to be set at a federal level that gets rid of some of that uncertainty. One of the things companies really like is certainty. And also, you know, some of the major companies have expressed ideas that they might be better technologically to manage carbon more than anybody else. But to make that profitable for them, they need to be able to get money for managing carbon or getting rid of it or taking it out of the atmosphere or suppressing it in some way, you know, doing all those things. And it's true. I think if you were to ask at least most large publicly traded companies right now, they would love to have a consistent federal policy. The fact that we have no federal policy on pricing carbon doesn't mean it's not going to happen. Everybody thinks it's going to happen at some point. It just leads to uncertainty. Nobody seems to know when. That's just my opinion.
Yeah.
And I'll throw another 2 cents on top of those. In terms of your question, Chuck, about how companies navigate the conflicting price signals we're seeing on carbon, and making those realities, incorporate them into their statements. The truth is that companies have to strike the balance. They have to recognize that there is a spectrum of different types of pricing out there that could affect the valuation of their assets. They have to disclose that in a way to investors in a way that makes that range of risks clear. And they have to be specific enough that it actually conveys credible and reliable information. It's not just a vague generality. But that does require them to do some very careful balancing until we get to a point where, as Victor has mentioned, we do have a clear, consistent, presumably at some point, federally influenced or driven price on carbon.
Yeah, it makes it challenging. Well, let me take it maybe a little different direction. Okay, we talked about contingent liabilities and the expectations of carbon and how the climate's going to change, and really it gets down to risk. And in some ways, I guess, pricing risk into your forward view that you're telling your shareholders about, or you're telling your employees, whatever. So let me take a different example. You have windmill companies and you have solar panel companies, and they will have an end of natural life to those facilities. And then they'll need to find places to bury these things. I don't hear much in the marketplace about contingent liabilities and concerns in that arena. Can you speak a little bit about maybe what you've observed?
Well, I'll start with what we know a little bit about with windmills. It's absolutely true that based on how they're made, the materials that are used and their size, they are not something that can be disposed of in a sort of typical way we dispose of things. If they were, you could just price that, right? How many, cubic feet, how do you move it, where do you get rid of it, et cetera. So there is uncertainty there. And I know that companies are having to delineate that uncertainty and try to predict what's going on. And of course, the bigger problem with that disposal of, say, wind turbine blades is that the newer, larger, more composite materials are the ones that are the more difficult. The older ones are probably not the very first generation, or may not be as difficult. So that's one thing. I think the other thing, though, that can come out of sort of nowhere, and I don't necessarily see this with carbon or solar, but it could, with wind or solar, but it could happen, is there some other disposal risk that we don't think about now, or we're not pricing? So for instance, are there toxic materials in the solar panels? We now know that we dispose of electronic items differently than we dispose of other things. We're supposed to do that, right? That's because of certain toxic materials that could leach into the ground. So does that mean that they have to have a special place, right, to have disposal? Does that special place mean that it's going to be more expensive? Probably. How much more expensive? Who knows? Will it influence, looking back, how they manufacture things going forward, right? Is that why we're seeing a push to create film rather than panels, things that are more easily disposed of or aren't as toxic? So these are all iterative questions that go back and forth. And again, if everybody's attempting to make a good faith effort to address what those risks are and how much those risks cost, then presumably the market is at least one good way to discover that information, right? And to give market signals to people to do something different, let's say, or to come up with a different sort of product. So,
sure. And
yeah, go ahead.
No, I didn't interrupt you, Victor. Go ahead.
No, go ahead.
We'll go back and forth this way. I'll just go out on a limb. And Victor, tell me if you've heard different. But Chuck, to my knowledge, I've not heard of any actually filed or threatened litigation that raises similar types of false claim dimensions to the use of wind or solar power. I think that might be because of a couple of different factors. The first is, for at least turbine blades, they do pose a disposal issue because they're bulky, they don't decompose as well, you can't recycle them. But I don't think that if you even went through a federal or state testing that they'd qualify as hazardous waste. And they certainly don't seem to have a direct impact on water quality. So they don't pose that sort of dimension you normally associate with the kind of environmental problems that people get really worked up about. In addition, solar panels do have issues about being properly disposed. They do have toxic heavy metals associated with some of the varieties of them. But as Victor's mentioned, the technology is evolving and they're trying to reduce those toxic footprints. But the larger, perhaps more relevant reason why you don't have that same sort of translation of liability for speech is that those disposal and environmental impact issues tend to be very, very local. It's where that blade gets put on the ground. It's where that solar panel gets sent to a rendering plant. And as opposed to climate change, where the potential impact is systemic and it's one that has a very long time horizon and can have some large impacts on large numbers of people. So litigation over the veracity of statements related to it is a much more attractive vehicle if someone wants to raise a claim.
Yeah, I could certainly see that point of view. I understand that, and maybe it isn't nearly as, I guess, viewed as existential in terms of that industry as opposed to the climate and the air that we breathe. I just can't help but remember the nuclear power industry paying into the Yucca Mountain program that all of a sudden the government changed on them at the last minute. And I guess you can't hold someone legally responsible for that kind of a pivot, or can you?
Not really. States has been trying, that's for sure.
Again, people will try, and people have tried. And there was a raft of incredible lawsuits against the nuclear industry in the 1980s, but that was over expected electricity prices and where they were going and how much they could charge and whether the regulation would pass through or not. And lots of people lost money. Yucca Mountain, it's a government policy that has gone away. The only question these companies have to answer is, were they correct in depending on that to look forward to that going forward? I mean, you may think it's a sad world where we can't depend on the word of the government, and I would hope that generally we can, but that's the situation that has happened in that case.
Mm-hmm. Well, another question I guess that leads to is it's business risk generally. As the landscape of the attitudes change in the world that we live in, those business risks, again, I guess to reemphasize your point, it's really doing the best job you can with the information you have available, and that being the primary litmus test? Or do you see some type of a legal standard coming out? I mean, people always search for standards or something that they can get a stamp of approval, again, to try to eliminate the risk of not doing it correctly when you sort of don't know what you're supposed to do anyway. I mean, I don't mean to make light of it, but it just seems like a difficult challenge for industry to walk itself into.
Oh, you're not making light of it. It is a difficult challenge. It's a really incredibly difficult thing to do. And just to reference something that Tracy talked about earlier, in 2010, the SEC put forth a guidance to assist in that, right? To tell companies what it meant when they said they needed to disclose risks from climate change. They talked about the three risks: the physical risk and the risk of regulation, and market risks, right? So, and of course, that guidance has been withdrawn. Now you've seen organizations trying to fill that. The Sustainability Accounting Board is looking to set up sort of generally accepted standards. And if companies adhere to those, at least hopefully that is some kind of a safe harbor, right? And we sort of now have a consensus, I think, and most very large companies and publicly traded companies do tend to follow this in terms of financial disclosures, at least to the SEC. And that will continue to evolve. But you're right, if we had a specific standard, I suppose the downside could be that that's the minimum and nobody would go above that. But the upside is at least we'd get consistent information and these companies would know what they're supposed to do.
Well, Victor, and that sort of leads to another thought that oftentimes, I guess it's probably true in any type of a liability situation. You have international and national oil companies and energy companies that have enormous balance sheets, and they become the targets for much of this international legal discussion around what did you know, what didn't you know, and I'm going to extract some kind of a monetary damage from you, et cetera. You've got lots of oil and gas companies that are not anywhere near as well capitalized, et cetera, et cetera. And so is it just generally accepted that the big guys are going to have to shoulder the burden of all of these types of conversations? Because I don't really see a lot of the smaller, the mid-majors and the small independents really involved in much of this conversation, certainly in the oil and gas community.
I think I would just point out there's sort of two different things happening simultaneously. One is there is a concern that any more extraction of fossil fuels and moving it into the atmosphere should not happen. There's a group of people that just don't want that to happen. And so in that sense, you could be saying they're using legal tools in order to try to move that faster and closer to reality. So in other words, the end goal may not be to extract money, or it may be somewhat, but the end goal may be to get particular regulation, or to make it more difficult for companies to function, or to, if you're an economist, to say, well, maybe it's more economically efficient if externalities are priced in. On the other hand, there are some locations that are actually seeking actual money, right? That perceive themselves as being damaged by climate change, like large cities that want to update their infrastructure to handle rising sea levels. And in that sense, the major companies, which don't even produce, I guess, even 13% of the oil and gas. I mean, if you take, if you're not looking at the nationals, they, are the biggest targets, as you point out. And so, if you're going to get some relief, that would be one place one might attempt to get some of that relief. Again, it's using the legal system as a replacement for effective and efficient regulation, I think, is not ideal. But in the absence of that, you're just going to continue to see more litigation occurring, I think.
No, absolutely. And it's just as a small side note, oftentimes litigation is the precursor to regulation. As a welter of lawsuits develop on multiple different jurisdictions and different issues pop up, you oftentimes will see states or federal government step in to try and impose more uniformity. So sometimes litigation is expressly brought with that ultimate goal in mind.
Yeah, I'll have to admit, this is going to be my question. It hasn't come from the audience, but I mean, as an example, we've had an endless conversation about the oil sands pipeline coming into the United States. And it's been in the news and people have talked about it forever and ever. And we have a whole statute of environmental efforts that need to be submitted, approvals through the Army Corps of Engineers. It's a standard and I guess a permit by rule type approach that's in the world, and it's a standard for operating, and it's something that requires investment and due diligence by companies to go through. And then when you get to the point where you've actually achieved what you believe now is a conclusion, then there's a conversation that comes up about climate change or something unrelated to the permitting process, and immediately it's in a tizzy and it's set back once again. And I don't know, I'll use the term legal extortion almost in some ways. It's somewhat maddening, isn't it?
Well, I will say I have never liked the idea of using law outside of its particularly intended purpose. But I will, you're really taking me back, Chuck. You're taking me back to when I was in private practice and I was an attorney and I specialized in National Environmental Policy Act and NEPA. And what I told clients then that they did not want to always hear was, if there's any possibility that this will be raised, you need to address it now, right? Everybody wants a quick fix. Everybody wants to go through it rapidly. And that's the mistake a lot of administrations have made, including the Trump administration, in seeking to quote unquote shortcut the process. Because unless the law itself is changed, as you point out, it's a very specific way of doing things. It's onerous, perhaps, it's expensive, but it is what it is. And if you try to short circuit it and go faster, you keep getting these slapbacks and keep getting these slapbacks. And it ends up making the whole thing less efficient. Now, climate change has certainly been on the environmental NEPA world since any of these pipelines were proposed. Everybody's known. Now, how you consider climate change, right? Do you have to consider the tertiary effects, or do you only consider the secondary effects and that sort of thing? That has been an unknown legal decision at this time. But to use NEPA as an example, NEPA itself doesn't prohibit things that are environmentally destructive or whatever. They simply require information. And so to me, if you're a company, my advice to you, and I'm not licensed to practice law in the state of Texas, by the way, I'll just say that. I practiced back in Seattle. My advice to you is to do the due diligence and the best you can up front. I know most attorneys would go for this too. And yet, you're right. Even with that, you get a different court case. The court says, oh, when we say environmental effects of climate change, we don't just mean on that local, habitat. We also mean the impact of the emissions that this transported thing will occur, or we don't mean that, right? So yes, those things can come up, and we've seen a lot of that, obviously, with the pipeline situations.
Sure. If at the risk of perhaps repeating what Victor said, but much less eloquently, one thing to keep in mind is that the Keystone XL pipeline has repeatedly caught in snags, not because of climate change challenges. That is the motivating factor behind a lot of the challenges, but essentially it's a debate by proxy. The most recent disruption, for example, is due to failure to do consultation on the issuance of certain types of nationwide permits by the U.S. Army Corps of Engineers for endangered species. Nothing about climate change is buried into that. But if you look at land acquisition, if you look at potential incursion onto religiously protected values of tribal authorities, if you look at the way that the NEPA accounts were taken care of, the fact that it was crossing international borders, there's a toolbox of different challenges that can be raised. If you object to a project because of climate change, you don't actually have to integrate climate change expressly or explicitly into the debate. And that's maybe one way to deal with it, is just to try and get at the root of what the argument is really about, because there's always an opportunity to revisit and relitigate issues. And even if you ultimately get that pipeline built, as we've learned, it can be 10 years and a lot more money later.
Pretty difficult. We're getting close to the end of our 90 minutes here. Tracy, do you have any other questions that we haven't asked, or things you'd like to reflect on really in summary? And I'm going to ask you the same thing, Victor, here before we close, but maybe Tracy, you can start.
I'll do that in two tranches. First one is I did get a chat question that was sent to me. I think it was sent to me privately, so Chuck, you may not have had a chance to see it, but it just basically, someone wanted to get perhaps a little bit more detail about what Justice Alito's concerns were in the Mann certiorari dissent. And I would just, to boil it down, and this is perhaps a larger issue for our climate liability discussion for speech, he is very concerned that an issue that would allow a defamation action to be brought, challenging veracity of statements on what he characterized as a highly contentious and politicized question, struck to the heart of the values of free speech protected by the First Amendment. And he wrote an 8-page dissent objecting to what would normally be a routine denial of certiorari for the court to hear the case. It's worth paying attention to that note, because one feature about this court that's very striking is that there are some very passionate supporters of a very sharply drawn First Amendment. And this court has been willing to protect speech that other earlier iterations of the Supreme Court have not been willing to protect. The collision between some of these very fundamental First Amendment beliefs by the current bench, including Justice Kavanaugh now, with some of the emerging theories of liability for statements that are false about climate in a speech arena, we're going to have to sort of see how those two intersect. And I don't think we've gotten there yet, but the fact that we are starting to see dissents, the court's trying to signal to the legal world that they're interested in this issue. In the tort context, we've had interesting, for example, some signals from the court about how they view some of the tort cases in the Ninth Circuit. Watch the Supreme Court. in a larger sense, I'll just simply say this, that it's going to get easy to muddle, that there's a large debate about climate liability at its root. Who caused it? Should they be held responsible? Does it even make sense to even try? If they do, how do you figure it out? And should this be something being done in piecemeal litigation or through legislation? That's all about liability per se. The separate parallel debate is over what you say about it, and the way people rely on what you say about it is under a different set of rules. The two are going to interact, but we're going to have to watch and keep in mind that there is a line between the two. And we need to be focusing on making sure that the rules applying on the speech side make sense as work continues to on the other side. And with that, I'll pass the mic back over to Victor.
Thank you, Tracy. I actually have just gotten a couple of questions too. I guess people saw this as their last chance. One is about liability of public officials for misstatements about climate. I will just note that in general, if you can show that there's sort of damage, et cetera, and somebody can otherwise be sued, they can still be sued. It's different if the public official is an attorney. If that public official is an attorney, they may face ethics issues if they deliberately lie or just lie. A case was brought against the prior governor of Florida for saying that sea level was not rising, when, as we've talked about this, Chuck, that's a demonstrably proven falsehood. And so there is that. The other question was about the difference between, a slight difference between product liability and failure to warn and perhaps some of the financial disclosures. And that is an important distinction that I did not make clear. So in the financial disclosure situation, as Tracy and I pointed out, there's a sort of a negligent standard, right? You have to do your best, investigate, and do all kinds of things like that. In product liability, that's a strict liability statute. And different states have different rules about what you're supposed to do. But what that means is, even if you've done, you were right at the time, or you didn't know about risks at the time, you have to go back and revisit those. And now if you do know about risks and they're scientifically accepted risks, you must warn about those, right? So it's an even lower standard to meet. And so again, all these are various legal situations. Again, this is a lot of information to cover. Law is not necessarily the best tool to have the debate about climate change, but it certainly is being utilized in that arena.
Well, I want to thank both of you. I think what consistently comes back through conversations that I've had in the marketplace with many of our industry sponsors, and those that aren't in the industry but are in the marketplace, the University of Houston School of Law recognized for a lot of the depth and breadth that you guys have brought today. And it's a real pleasure to have you both on. I just want to say, for the record, because you brought it up at the very beginning, I think both of your jackets are quite smart and good looking. And so that's a fact. Okay, that's a fact. Okay. So anyway, with that, thanks so much. And I guess for all of you that have joined us today, we really appreciate the fact that you've taken the time to spend it with us. We would encourage you to further and continue your involvement with the University of Houston Energy, and certainly our Center for Carbon Management and Energy. And if any of these conversations have sparked an interest to pursue it in any of your own personal development, or that of your enterprise that you work with and for. Next week, we'll be back again at 10:30 on Thursday for digitization in the energy industry. Greg Bean will be presenting. And again, as I mentioned earlier, a white paper will be posted later this afternoon on our website so that you could get a preview of what we'll be talking about next Thursday. And I think the transformations that you'll see in that paper that we're suggesting will be fundamental in the way we do business going forward, and the technological and business model changes that will be occurring in the marketplace. So again, this will be the last in our series for the month of April. But again, our thanks to Hunt & Andrews and Kurth for their sponsorship of the April series. And we'll certainly enjoy having Hunt with us as part of our Center for Carbon Management and Energy as well. So again, all the best to you. Have a good rest of the week, and we'll see you next Thursday.